Good morning and welcome to the second episode of Coffee with Casey. I'm Casey Hicks, a shareholder of the Chicago office managing attorney here at Weltman. I think I already need some more coffee this morning. Thank you everyone for signing on for this session, and I'm looking forward to discussing collateral recovery this morning. Today, I'm enjoying a nice big cup of Big Shoulders coffee. How about all of you out there? Feel free to put your favorite coffee or drink of choice in the chat feature while we introduce today's guest. Drew, good morning, and thank you for being the first guest on the series. Would you mind telling everyone a little bit about yourself? And don't forget to tell us what type of coffee you're drinking today.
Well, I'm drinking the same coffee that you are because you are the master of the coffee machine. Very nice coffee machine, I might add. My name is Drew Walgreen. I'm an attorney here at Weltman, Weinberg & Reese here in Chicago. I've been with the firm for 6 years. I'm a graduate of the University of Michigan in Ann Arbor and went to Marquette University Law School. Grew up here in Chicago, but have family ties to Milwaukee area. So born and bred in the Midwest. Been licensed since 2013. I'm also licensed in Illinois, Wisconsin, and Florida. And my primary focus of my practice is foreclosure, collections. I do some collateral recovery as well, which is obviously the subject of what we're going to be talking about today. My interests are travel, finally able to travel again. A little jet lag from some travel this week, in fact. So, yeah, happy to be here today.
All right, thanks, Drew. Before we jump into the presentation, there are a few housekeeping matters that I need to go over. As a reminder, this is an interactive session, so please submit any questions you have throughout the presentation through the question button in the control panel. Also, this webinar is being recorded. At the conclusion of today's session, oh, I'm sorry, I think my webcam is off.
I think it might be.
Okay, I'm sorry. 1 second, technical difficulty. There we go. Hi, everyone. All right. As a reminder, this webinar is being recorded, and at the conclusion of today's session, a link to the recording will be sent to all attendees. There will be a short survey on your screen at the conclusion. I'd appreciate it if you take the time to complete the survey and share any feedback that you have. We greatly appreciate hearing any opinions on our webinars, or if you have any suggested topics for one of our next episodes. We plan to conclude by 9 a.m. Central, 10 a.m. Eastern this morning. And before we get started, I do have to go through our legal disclaimer notice. This seminar presentation will provide information concerning potential legal issues, concepts, factual situations, and information. The seminar and the material provided is not a substitute for legal advice from qualified counsel on any matter, including similar or exact factual scenarios that may be provided or proposed. This presentation is not created or designed to address the unique facts or circumstances that may arise in any specific instance, and you should not and are not authorized to rely on this content as a source of legal advice. I advise you to seek competent legal advice on any topic discussed today. This seminar or seminar material does not create any attorney-client relationship between you or the law firm of Weltman, Weinberg & Reese. All right, now that we've done that, let's get right into it. Today, we're going to be discussing repossessions, replevins, impound seizures and forfeitures, and labor and storage liens. And Drew is going to kick us off with pre-repossession issues. Take it away, Drew.
Thanks. So there are a number of considerations that go into kind of the pre-repossession space. The first is a determination in terms of whether or not the debtor is in default. And one of the first questions is, how are you determining that event of default? Is there a payment default? Have they missed a certain number of payments? Did the loan mature? Did the debtor do something with the collateral that constitutes an event of default, such as transferring it without consent of the lien holder? Or is it something where, it's commercial and it's maybe payable on demand, and, the bank has information in terms of whether or not, the debtor's financial situation is deteriorating, something of that nature. A determination that needs to be made too is whether or not the collateral is worth the cost of going through the repossession replevin process, Right now, obviously, we're seeing, pretty high prices for secondhand, collateral, especially like in the used car market, for instance. We also need to confirm that the lien is properly perfected, according to, whichever state you're in, or, if there's a UCC filing, things of that nature. Need to confirm that the debtor is not in an active bankruptcy. That's something that, can be done pretty easily with the borrower's social security number through PACER. Need to confirm, through an SCRA search that they're not an active military status. And then need to determine, which law applies, which state law would apply, which is something that's usually governed by the terms of the contract. If it's silent, there's obviously probably where the collateral is located is what's going to apply. There are various self-help avenues. We need to keep in mind, taking an inventory of the property, what state law is going to be applicable, what contract language might determine what remedies might be available to you in terms of going about the repossession. You need to be mindful of different restrictions that are in place in terms of taking action to repossess the property. You need to make sure that, if you're taking these steps on your own without court involvement, that you don't take any action that would constitute a breach of the peace. There are a couple of different factors that we have listed here. One of which is, any sort of action that might damage some of the debtor's property in the collateral, that they may come back later on and claim that happened, which, could be ground for something like a countersuit or something of that nature. Repossession letters are very important. They're governed by state statutes. They're very specific. Most of the states follow the Uniform Commercial Code. If the repossession letters are not properly formatted, they don't include the correct information, there could be an issue where you're not able to go after the deficiency balance. You could get sued. And then we also would not be able to institute a collection action after repossession for the remaining deficiency balance due. There also could be, a risk of a class action if it's done a certain number of times. So, in the event that there are questions in terms of whether or not the repossession letters that are being sent are proper, we're happy to review it. Wisconsin has some very specific provisions in terms of giving the debtor a right to cure the default. The loan has to actually be in default, and this is usually defined as more than one full payment is more than 10 days past due. This notice has to be given to the debtor by regular mail, but sometimes contracts can also specify that it has to be sent via certified mail, so it's important to be mindful of what the contract says too. You have to wait 15 days to conduct the repossession. After that, they have 15 days to redeem the repossessed vehicle. So the loan has to be over $25,000 to be paid in full, and the payment has to include an amount to bring it current and a performance deposit, which is equal to 3 payments, and it has to be under $25,000. This is a very strict statute and has to be very closely followed. And there are, pretty significant penalties in terms of what can happen if it's not followed.
Oops, I'm sorry, skipped ahead there. Okay, repossession letters in Illinois, pre-repossession letters. There's typically no notice required in Illinois prior to a repossession. Again, like in Wisconsin, the loan must be in default. A default in Illinois could be even 1 day late on a payment. There is a post-repo notice that is required to be sent within 3 business days after a repossession. And in Illinois, we have this very funky 30% rule. If over 30% of the loan is paid, the consumer has 21 days from the date of repossession to either reinstate or bring their account current. If under 30% of the loan is paid, the consumer has 21 days from the date of repossession to pay the account in full. And in Illinois, the post-repo notice can also include the notice of sale. We did get our very first question of the day today, so I'm going to go ahead and read that. Do you have to try repossession of collateral when you're suing for a default, like on an auto loan, or can you just sue without any repossession efforts? Basically, is repossession a prerequisite for suing in Illinois? No, any attempt to repossess in Illinois is not a prerequisite to filing a replevin or debt new action in Illinois. These are just self-help remedies that you could attempt on your own before you would refer it out for a lawsuit to attempt to gain possession through that lawsuit.
So I'm going to talk briefly about Wisconsin in terms of the notice of sale. If the consumer does not redeem as a secured creditor, you can either keep or sell the collateral. If they've paid more than 60% of the loan, the consumer can demand a sale. The consumer has to receive a pre-sale notice that states when and where the sale is going to occur.
And in Illinois, the letter mailed after repossession but prior to sale, as I stated, it can be included with the post-repo notice that's sent 3 business days after the repossession. There are certain requirements that must be included if the sale is going to be a public sale. Must include the date, time, and the place of the sale. If it's a private sale, there are different requirements that must be included in that notice, and it must include the date after which the sale will be held. After the sale, if there is a deficiency or a surplus in Illinois, there must be a letter sent that details and explains how the sale proceeds were applied to the consumer's loan. They're typically applied first to the reasonable expenses and costs of repossession, then to the loan balance. In the past, surplus has been rare, but as Drew mentioned, with the increased prices of cars that we're seeing in today's world, if there is a surplus, it is given to the consumer unless there is a cosigner, and that cosigner has the right to excess.
And Wisconsin is relatively similar. The consumer is entitled to any surplus that might result after the sale of the collateral in question. If the deficiency amount is less than $1,000, the consumer does not have to pay it.
And we did get another question that came in. And the question is, if you file a debt new action and discover the location of the vehicle and it is in the defendant's garage, can you do some sort of motion to allow the sheriff to enter the garage? So that question is going to take us actually to our next topic, replevin and debt new. Within replevin and debt new, replevin is an order for possession that you get when the sheriff will execute on that order. A debt new can be enforced personally against the consumer or defendant within that lawsuit. So when we file replevin and debt new actions, we file 3 count suits. We file a count for replevin, which will allow the sheriff to execute. We file a count for debt new, and then our 3rd count will be the breach of contract count in case there is a deficiency. We want to be able to collect on that deficiency, get a judgment for that deficiency balance within the same lawsuit. All right, replevin, kind of already touched base on this. It is a possession order that is executed by the sheriff. One of the differences between replevin and debt new is that for a replevin, for the sheriff to execute on a replevin order, we must know the location of the vehicle to send the sheriff out to. So if you do know that it is in a garage, where that garage is, then we would need that information so we could send the sheriff out there to that garage. And with execution on replevin orders, a bond is required, and that bond typically will be for double the value of the collateral. We work with a bond company here to get those bonds on your behalf, so we will have that when we place replevin orders with the sheriff's office. Okay, debt new, it's recovery of specific personal property that's been wrongfully detained, or the value of that property if damages cannot be delivered. Once possession is awarded to the creditor, that possession order can be enforced through civil contempt proceedings, such as a rule to show cause, a body attachment, or a bench warrant. We do have another question that came in. Thank you guys so much for asking these questions. They've all been great. Can you recover any cost of trying to repossess replevin, for example, cost of towing, cost of investigator to find a car, cost of storing while waiting to sell? So all of those expenses or costs would be wrapped up in, we would need an affidavit basically specifying what those costs are. We would provide that affidavit to the court when we moved for judgment on any deficiency balance. Some costs might be deemed excessive, some might not, but your typical repossession costs, those can be included when you're applying the sale proceeds to what's owed on the loan balance. If there's any more specific questions about that, happy to discuss later. My contact information and Drew's contact information will be on the very last slide. We'd be happy to discuss further any specific questions regarding like costs and things like that. There was another question that came in as well. In Wisconsin, you said if a loan is over 25K, it must be paid in full. Why must? Drew, feel free to jump in here, but there are two different statutes at play in Wisconsin, and the Wisconsin Consumer Act applies to any loan that is under 25K, and then there's a different statute that applies to any loans over 25K. So that's where that difference is there. And I don't think I missed any questions, but they've all been great so far. So thanks so much. All right, impound, seizures, and forfeitures. When a law enforcement agency seizes or impounds a vehicle, there are steps that a creditor can take to recover it. Typically, this is going to happen if you have a customer or a consumer that is pulled over for a DUI or some sort of traffic violation. Sometimes the vehicle that was used in the commission of that crime is seized by a law enforcement agency. So there are ways for a creditor to get possession of that vehicle within the seizure or forfeiture proceeding. We handle quite a bit of these here in Illinois, especially in Cook County. And a verified claim on behalf of the creditor is submitted to the local state's attorney's office that is prosecuting that action. We'll file an appearance and an answer within that case, attend all the court hearings, and then we will work with the police department that seized that vehicle to get possession for the creditor. Sometimes towing and storage costs accumulate, and especially the storage costs, they can be very, very, very significant. A lot of times a forfeiture or seizure proceeding can go on for months, depending on what that underlying criminal case or criminal charge is. So we work with the state's attorney's office, the court, and the local police department to try to get those fees reduced before the creditor takes possession of that vehicle. And like I mentioned, if it's a severe criminal case that's going on for months, the civil action will just kind of sit there waiting for that criminal case to be concluded. So those storage fees can be racking up for months within a pending forfeiture or seizure proceeding. We did get another question that came in. If you have a detinue and a bench warrant because the consumer did not surrender the collateral, can you turn the detinue into a money judgment without having to serve the person again? So yes, if you filed your 3-count lawsuit that includes replevin, detinue, and breach of contract. That breach of contract will include the full amount of the debt at the beginning of the proceeding. We serve all of the defendants with a summons. Once they're served within that lawsuit, you can proceed on count 1, replevin, count 2, detinue, count 3, breach of contract. So if you've gotten a possession order and you're still not able to get possession of that collateral, you can then move forward to get a money judgment on that breach of contract without serving a summons again. To execute contempt proceedings for failure to tender possession on a detinue order, the consumer defendant does have to be served again with either a rule to show cause, with a rule to show cause, and if they fail to respond to that rule to show cause, then the bench warrant will be issued. So if you're executing civil contempt proceedings, service does have to be made again. All right, labor and storage liens.
So this issue is somewhat complicated, but I think the major points here are the fact that towing lien is going to have priority over the lien holder's lien to the extent of $100 for a vehicle with a weight rating of 20,000 pounds or less, and $350 for a vehicle with a rating of more than 20,000 pounds. And just ignore the dollar sign there, meant to be 20,000 pounds. In terms of storage liens, they have a priority in the amount of $10 a day, but not more than $600 for vehicles that have a weight rating of 20,000 pounds or less, and $25 a day, but not more than $1,500 for a vehicle with a weight rating of 20,000 pounds or more. Mechanics liens, which are basically, liens that are imposed by a shop doing repairs on the vehicle, are subject to the security interest for anything over $1,500, but it may vary depending on the collateral type.
All right, in Illinois for labor and storage liens, we have two statutes that come into play. The first one is the Small Lien Act, and that is for labor, services, and material furnished in the amount of $2,000 or less. That mechanic that has done that work has a lien on the collateral. This small lien of $2,000 or less does have priority over a lien holder that has a security interest in the vehicle in most instances. A lien holder must receive notice via certified mail, return receipt requested prior to the assessment and accrual of storage fees. And the effective date on that's going to be the date that the tow shop or the mechanic shop mails out that notice. And that notice must include the daily amount of storage. So if it's $50, it must include that specific amount of storage, that storage fee that's going to be assessed on this vehicle. If the collateral is registered outside of the state of Illinois, storage fees may commence on a date that the mechanic shop or the tow shop makes a request to determine if there is a lien holder that holds a lien on the vehicle that they have. And a copy of that request would be provided, and then once they get that there is a lien, once they get the information that there's a lien holder on this vehicle, they are required to send the notice by certified mail, return receipt requested within 1 business day after receiving that lien holder information. And if they do that, they can begin to assess the storage fees from the date that they made the request for the information on the lien holder.
So
like
I
mentioned,
have a question there, if you don't mind me interrupting, Casey.
Yeah, go right ahead, Drew.
I think it might be helpful for some of the people in the audience. What happens if the lien holder doesn't receive the notice in the format contemplated? So here we're saying it's got to be via certified mail, return receipt requested. What happens if they don't do that, or they don't provide the information that's required in terms of the content?
If the shop does not follow the statute specifically and send the required notice according to the statute, then they cannot assess those storage fees to the lien holder until they send the required notice. And then they could start assessing the storage fees from the date that that notice is sent.
And when do we typically see some of these lien holders appear? Like in terms of when do they typically show up, or when do we know of their existence and their claim?
So it kind of depends. I've seen a lot of different types of situations. Some shops, larger mechanic shops, are especially in Illinois, they know what they're doing. They know that they have to send the notice. They know where to look for the lien holder information. Some smaller type shops and tow shops, they really don't know. So once they start trying to either get the registered owner to pay, realize that they can't pay, then they start looking around and trying to get the lien holder to pay, and they might not necessarily know that they needed to have sent this notice to the lien holder. So it's important for lien holders to know their rights in this situation, because if a storage fee of $50 per day or $100 per day is being assessed on a certain vehicle that a shop is holding, those fees can add up relatively quickly. So we would not want the lien holders to be taken advantage by a shop that doesn't necessarily know what they're doing and they haven't sent out the correct notice. And the second statute that comes into play in Illinois for labor and storage liens is the regular lien act. So this would apply to a shop that has a lien for $2,000 or more. So it's going to cover the same thing: labor, services, any materials that were furnished. They would get a lien on that collateral. The same notice is required as the small lien act, still effective on the date of mailing. And also it has the same requirement if a piece of collateral is registered outside the state of Illinois. This lien created is subject to a security interest lien. So any lien over $2,000 would be junior or subject to the lien holder that had the purchase money lien holder. This is in contrast to the small lien act, the $2,000, which would have priority over a security interest lien.
And with some of these liens, like that the shops are claiming, do they have to prove the amount that they're due? So like, do they have to produce the invoices saying that, okay, I assessed, say I did, you know, $5,000 worth of work to repair a broken engine or something like that? You know, I'm not a mechanic, but you know, do they have to demonstrate, make some sort of showing, you know, hey, look, you know, you can't just come out willy-nilly and say, you know, the lien holder can't just say I'm owed, you know, $15,000 and just, you know, fill something out and file it. But they have to provide, you know, like invoices or, you know, some sort of documentation backup. And also with the storage fees to make some sort of, I'm answering my own question here, but, you know, make some sort of showing that, you know, we typically charge $50 a day for the storage after it's not picked up after a certain amount of days. And this is something we do, and that's usual and customary. I mean, I feel like I answered my own question there, but if you want to jump in and.
Yes. So typically what we'll do when we get a type of file like this where a shop is requesting a pretty significant sum of money for a labor and storage lien, the first thing that we're going to do is we're going to request copies of those invoices, right? So we're going to want to take a look at what they are charging, what they say they've done, and the price, you know, for those services. We would try to obviously negotiate with the shop if we think there's, you know, maybe something fishy going on. We always have the option to file a replevin case to get possession of that vehicle and have the court or the judge decide what the value of their lien is. And if it's, you know, over 2,000 or under 2,000 or exactly, you know, what the price of it is, then once the lien amount for the shop and obviously the lien holder is determined, once possession is in the hands of the lien holder and that vehicle sells, then there might have to be a payment made if there's a surplus, of course, to the shop for whatever their, you know, $15,000 for an engine or whatever. Then there might need to be a payment made out of any sort of surplus. But if the mechanic lien is subject to the lien of the lien holder, they would be a second payment after that sale. But if it's under 2,000, that would be the first payment going out after the sale because it would have priority over that security interest.
I think my only other kind of add on to that too, and it applies kind of outside of the labor and storage lien space, but once the collateral has been repossessed and it's been sold, you know, in addition to the notices, do you think that the secured creditor should be keeping track in terms of like the invoices for remarketing and selling, invoices for repairing the vehicle, things of that nature? Should they be keeping track of that?
Yes, exactly. Because we're going to want to know we're going to want to have all of that information when we prove up those costs to the court. We did get one question in again about this $25,000 thing in Wisconsin. So the question is still a little unclear. I meant, what happens if we don't ask for the full amount if the loan is over $25,000? Do we have to ask for the full amount, or can we just ask for the amount past due plus performance payments? So little tricky situation here because of the statutes that apply. Of course, if you have possession of the vehicle, you want to tender that possession back to your customers so that they can begin making payments. You might have the option to request less than the full amount on a loan over $25,000. The statute indicates that if it's a loan over 25,000, that you're entitled to request full payment on that loan. And with that, that brings us to the end of our presentation today. Thanks so much again, Drew, for being the first guest and helping me out today with the collateral recovery. I hope everyone here in the audience found today's presentation informative. Drew and I's contact information here is on the screen. Feel free to call us or email us if you have additional questions, or if maybe I didn't answer one of your questions today fully, maybe, I'm not sure, but I tried to do my best. You know, it is Friday and I do not think I have had enough coffee yet today. We are working on episode 3, so I hope all of you out there will join me on Thursday, August 4th. My guest for episode 3 is going to be Monette Cope. She is the bankruptcy attorney here in the Chicago office. So we're going to be discussing some bankruptcy issues and hot topics on Thursday, August 4th. And as a reminder, a short survey is going to pop up on your screen when the webinar ends. Please share your feedback. Let us know what future topics you would like to see discussed. And thanks again for attending, and I hope you guys enjoy the rest of your day and have a great Friday and a great weekend. Thank you so much.
Thank you.